Yo, come on in here, family. Got that Young Thug bond hearing going. You know what I'm saying? Come on up in here. Let me know what y'all think, y'all. What's gonna happen in this bond hearing? So yeah, family. They say Thugger ain't been in the courtroom yet. They on some recess. They recessing. You don't know what they recessing about. You know what I'm saying? But whenever Thugger come through, we gonna be right here. We ain't going nowhere till Thugger come through. Call it off work. Ain't going nowhere. We sitting right here on this line until Thugger come through. Straight up. What up, Lily? Yeah, I want to see what happened. Cause Yak Gotti lawyer, oh my God, he came straight off the back of the cereal box. I got a video coming later about Yak Gotti lawyer. I'm trying to tell y'all, it's crazy, man. It's crazy. Yeah, y'all, this crazy, man. Straight up. Hey, they gotta fix Streamlabs too, man. Streamlabs keep taking my sound in and out off the mic, man. What's to it with the Streamlabs? Why they keep adjusting my mics or my mic sound down? Oh, they tweaking. Bro, what is wrong with them? Yeah, y'all. I hope y'all can hear me because, like I said, Streamlabs, they keep taking the sound all the way down from my mic. I do not know why. But they keep taking the mic sound all the way back down. Let's see something. Yo, there you go. They shouldn't be doing it now, but they keep doing it though. I don't know what's to them. Lily, y'all can hear me? Can y'all hear them people talking in the courtroom? I want to see if they walk dog in there. Free dog. You know what I'm saying? That's what I'm waiting to see. Yeah, I want to see if they walk dog in the courtroom. I want to see what's going on with dog, man. James Bond, I see you. Corey D, I see you. Shout out to everybody in the chat, man. I'm trying to get these mic levels right. I don't know why they keep dropping my mic all the way back down to like 30 and 0, man. You feel me? Man, I don't know what's taking them so long to bring Young Thug into the courtroom. What, they left him at the other jail or something? But they don't know where he at or something. They can't find him. Where's Thugger? That's what I'm waiting to see. Straight up. But we right here until he walk out. We ain't going nowhere until he walk out. For sure, for sure. Puppy slide. Yeah, Lily, we definitely here for dog. You already know that. Yeah, we definitely here for dog, Lily. You already know that. Bro, I hate doing the most. Yeah. Oh, Chris, man, we waiting on Thugger. I don't know what Thugger at. I don't know, but this is the word camera angle. They say we going to recess and then pan the camera all the way to the corner. But I hear all these people talking everything. No Cap say Bellwood, Illinois here. All right, well, shout out to Bellwood, Illinois. You know what I'm saying? No Cap, you got anything else to say? Chris, I don't know. They went helping them get through some. Can y'all hear them people though? Let me know in the chat. Y'all can hear the court and all that. It's just a bunch of people in there talking right now. Cause they done went on recess. But we ain't seen Thugger yet. Where's Thugger? Okay, here you go. Let's see what they talking about. Memphis in the building. Shout out to Memphis, man. For sure. Let's go, Thugger. Where you at? Where you at, Thugger? They act like they can't even find Thugger. What's really going on? They paid $5 for a Yak Gotti lawyer though. We gonna discuss that later. Even though he a snitch, but woo, Lord have mercy. Yak Gotti definitely had one of them cereal box lawyers, straight up. Man, is Thugger fighting in the hallway? What? I ain't even see him enter the courtroom or nothing. Where's Thugger? Yeah, Thugger did a lot to get this lifestyle. 41 people in the building. I mean, 41,000 likes. Birdman numbers on them likes, man. Lily Yak Gotti lawyer was terrible. Wait till I do that video. If you're new to the chat, if you're new to the stream, we waiting for Thugger to walk on the scene. I don't know what's going on. They been here like 4 hours. He ain't showed up. I just started right now because we don't know when he's showing up. At this point, I don't even know where he at. You know, they said they had to transfer him because he was still trying to get Lucci killed. They zoom in on the judge. His mic don't even work. What the hell going on, man?
All right, good morning, councils and interested parties. We're here on
Let's go.
A couple of matters. The first one being the state of Georgia versus Shannon Stillwell in indictment 22 SC 182273. Here for state's notice of conflict of defense counsel and arraignment and bond. Mr. Sharp, good morning, sir.
Good morning, sir.
Okay, all right. I see you've been relegated to the cheap seats, and the fact that Mr. Steele and his entourage have taken up their seats. Would you like for us to provide you a seat?
I'm fine.
Are you good right there?
I'm fine here.
Okay, all right, okay, no problem. All right, just wanted to don't want you to feel you were left out. All right, and then the other position is the state of Georgia versus Jeffrey Williams, 22 SC 182273. Good morning, Mr. Steele, and good morning, Mr. Adams. And
Good morning, Judge.
all right, sir. All right, and we are here on the state's motion to disqualify defense counsel and for arraignment and bond. Is that correct? All right.
Yes, sir.
Okay, all right. All right, let me first make sure that I have the aforementioned. Is there anybody else I was missing? So I just want to make sure I have. Mr. Williams, can you, I'm going to mute you at this point in time.
Bro, the judge told them they was in the cheap seats. Damn, Thug. Is that Thugger?
Thank you, sir.
I think that's Thugger.
Okay, who is in S214? Violetta, can you unmute S214, please?
Sure.
All right, sir, in S214, what's your name?
Scott.
I'm sorry, one more time?
Michael Scott.
Maybe Mr. Rapoff's client.
We got a new character like y'all, Marcus Scott. Who the hell is that?
We resolved your matter. You're free to go.
Damn, he don't even supposed to be there.
He can't do that today. He said he's going to come out and see you, okay? Mr. Rapoff. Okay? He's going to come out and see you, but at this point, I'm going to excuse you for the day, okay?
That man don't even supposed to be there. We done with you. The hell you doing taking up space? You taking up space, nigga.
Because I can't
We done with you, nigga.
location. So I'm going to unmute you, okay? If we need to talk with you, we'll go ahead and unmute you, all right?
Yes.
All right, no problem. All right. Before we go ahead and get started, folks, I've had the opportunity to read both the state's motions as it pertains to Mr. Shart and Mr. Steele. And I've also had a chance to take a look at the responses that were filed on behalf of Mr. Steele as well as Mr. Shart. And stated you can take it any way you want, but I think that the court, if I can frame just generally your issue in this particular circumstance for the state, and maybe the defendant's position on it. For as it pertains to Mr. Steele, you're saying that there's a violation or there's a potential violation of 3.7, which is lawyer as witness.
Your Honor, we're withdrawing the 3.7 claim today.
Okay.
And Mr. Geary is going to explain
Judge,
that.
I'd like to explain that to the court.
Okay. All right. We'll go ahead.
Quickly. We have notified Mr. Steele that I personally interviewed the officer previously.
Hey, real talk. I ain't never seen nobody get kicked out the virtual court.
Concerning the hearing today, it became evident that the officer truly believed the statement that Mr. Steele, quote unquote, confessed. However, the rendition of what the officer went through, we don't think that legally qualifies, and we're not going to support that in this motion, and we're withdrawing that in this motion.
Okay.
The officer did speak with Mr. Steele, but the interpretation of what occurred is different, and we're coming in on the side that there was no confession given the completion of our investigation of that matter.
All right. So you're satisfied you will not otherwise
He's off our witness list, Judge.
require Mr. Steele to be to testify or be part of any foundation that.
Correct, sir.
Okay. All right. Mr. Steele, any objection to that? They're going to withdraw that particular issue as it pertains to as it pertains to lawyer's witness 3.7.
No, Your Honor.
Okay. All right. Madam, I apologize. Your name? I apologize.
Lizzie Rosenwasser.
Miss Rosenwasser, I can't see you without your mask, so
Here we go.
okay, now I see. Okay, all right, thank you, madam. All right.
Hey, I don't know who Mr. Smith is, but he confessed and they withdrawing his confession. What type of snitching did he do?
I have all three of you now. Okay. Okay. All right. So that having been settled,
Mr. Steele snitching. What type of shit is this?
Issue's been withdrawn. You still have 1.7 and 1.9, and I guess you're going to make argument on that particular issue, and to that effect. Is that correct, madam?
Yes, Your Honor.
As well as, is that the same basis that you're moving to disqualify Mr. Sharp?
Your Honor, to clarify for the record, we are only moving to disqualify Mr. Steele. What we filed for Mr. Sharp was a notice of conflict. We believe that all of Mr. Sharp's conflicts could be waived. We are asking today, and I do plan to go into this further in my motions for both motions, we are going to be asking today to have all the affected parties, if they wish to, come in and waive those conflicts on the record. While we do appreciate the written waivers that Mr. Steele has submitted, we believe that to ensure that the record in this file.
Hey y'all, Mr. Steele done did some telling. I don't know who he. They say he told on himself and they withdrawing that. Damn, how you snitch on yourself and they take that off the table? Oh, he in there telling.
That conflict could be waivable. So at this point, we would ask the court to inquire into that conflict because we do believe that Mr. Sharp's conflict, as it only affects a former client, may be a waivable conflict. At this point, a conflict exists, but that conflict could be waived under 1.7b, whereas we do not believe that Mr. Steele's conflicts are all waivable.
Okay, all right. All right, well, given that, then, madam, I'll go ahead and let you proceed, and then I'll let Mr. Steele respond if he should so desire, because it appears that looking at 1.7, and that reads as follows: a lawyer shall not represent or continue to represent a client if there's significant risk that the lawyer's own interest or the lawyer's duties to another client, former client, or third person will materially and adversely affect the representation of the client, except as permitted in Rule 1.7b. And give me 1 second.
The judge looking for more people to kick out. Hey, you done? What you still doing here?
And also, the court's had an opportunity to kind of take a look at the case law that the state, as well as the defense, has raised in this particular situation. And I've had to take a chance to take a look at particular Benucci Height. That's HEIDT versus the state, Wheat versus US. And it appears that what brings us here is that Mr. Steele under 1.7 has already kind of, because he's the lawyer that's representing his current client, has already made that determination that he can represent his client. But it appears that the case law then shifts to a couple of things and says that that either the court can inquire about a conflict, given that this is a criminal case with multiple clients, multiple defendants, and with multiple counts on its own motion. But if you are, the state is moving, or the other party is moving to disqualify him, that there has to be a violation of one of the violations under the rules of professional responsibility, and there should be some proof to that, or at least some particular Bernocchi, and that is BRNOCCHI versus Fortucci, and that's FORCUCCI 279 Georgia 460. It appears that in looking at Bernucci, that comment 15 to Rule 15, Rule 1.7 places the primary responsibility of resolving conflicts of interest on the lawyer undertaking representation. That would be Mr. Steele. A court may raise the question when in litigation there is reason to infer the lawyer has either neglected responsibility, and imposing counsel may raise the issue where the conflict is such as to.
Literally, I was eating some steak and cheese fries, listening to how Mr. Steele snitching.
Administration of justice, and then, of course, the case law directs.
Right, 130 people in the bid. I need 130,000 likes. Them likes up, man.
To advise an objection for imposing.
It's a Buddha lie. This is exclusive.
Can be used as a technique as harassment. So in order for you to have standing, which is one of the things Mr. Steele is raised, is that the lawyer having the conflict of interest simultaneously representing multiple defendants, which would in this case be formal representation. There must be a violation of the rules which is sufficient to serve the call on the question of fair and efficient administration of justice.
Hold on, Mr. Steele case involved multiple defendants? Ain't nobody getting out of free. Ain't nobody getting out.
Mention what Texas does in Henry Robinson, where opposing counsel must provide substantiation. So I'm going to need to probably hear something on that. So from looking at Bernice, I can raise the issue on my own, which I would have given what you said already. But
Yeah, that man told on everybody.
The burden is upon you since he's already made this decision. He
Gubble Gunner getting out. They ain't letting Gunner out. They call you can't let a leader out.
In particular. So we'll start out with him to begin with, and then you can move on to Mr. Sharp. Okay? Okay. All right.
Your Honor, so our purpose today in raising this motion, first of all, and I do recognize the court's notice of the law saying that these motions can be used for harassment. That's not our purpose today. Our purpose today is to ensure that each of the defendants named in this indictment, and that includes Mr. Williams, but also Mr. Blaylock, Mr. Stillwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, all present or former clients of Mr. Steele, also have their rights properly preserved. So one of our main concerns here is that none of these waivers are on the record. We would ask, even if this court were to deny our motion to disqualify Mr. Steele, that each of these waivers be made on the record. Right now, they're written, but we believe that in order to ensure that everything is proper on the record, and that we're able to create a perfect record in this case, that those defendants be brought here and their waivers be placed on the record. That's out of Taylor versus State. That's 320 Georgia Court of Appeals, 595. That's a 2013 case. In that case, defendants alleged on appeal that there had been a conflict in the lawyer, and as a result, they should get a new trial. However, because the waivers were actually made on the record.
Man, these dudes trying to snitch their way into a new trial. Lord have mercy.
Made on the record, the Court of Appeals found that any error was induced by the defendant's statements, and that as a result, the case was not reversible. So first of all, more than anything, we would ask that any waivers be made on the record, as opposed to simply the written waivers, which again, while we do appreciate, we believe are not sufficient.
Now, I don't know. Like the judge said, Mr. Steele name, like with Young Thug, but I don't know who the hell Mr. Steele is. I think that's a separate case. But what we do know is Mr. Steele a snitch.
Our concern is that as a leader of the gang, perhaps some of these individuals may feel influenced. So we would like them to be advised by this court on the record, and if they still wish to waive their rights, we believe that would at least cure some of these potential conflicts. However, Your Honor, our main concern, and I did hear the court cite to Bernucci, but our main concern is not
Mr. Steele is opposing counsel. What they opposing? They here, right?
While we do have concerns about that, our main concern lies with Mr. Steele's current representation of co-defendant Blaylock. Mr. Steele.
Who the hell is Blaylock? Nigga sound like he play basketball. I ain't gonna lie to you.
Direct appeal of his murder convictions. Mr. Blaylock was previously convicted of murder, a murder that occurred in.
Damn, Blaylock was out here putting in work.
That murder has then been alleged as one of the predicate RICO acts. So in this particular indictment, the murder for which Mr. Steele is presently representing Mr. Blaylock on appeal, that murder is also one of the counts alleged in this indictment.
That apparently, that case is.
Oh, so Steele is the lawyer that's telling?
But the appellate court already.
They talking about him like he a crook too.
The posture of that case right now is that Mr. Steele has filed an entry of appearance. We are awaiting, and I'll be handling that.
Steele is thug lawyer. Blaylock is the murderer. What the hell? Oh no.
Motion for new trial.
No cap, it's definitely a conflict of interest.
I believe
They was talking about Steele like he was a rat.
late this year or next year. But that is at the motion for new trial stage and the Superior Court stage. So he's currently representing Mr. Blaylock. And I'll notice that in his motion, Mr. Steele alleged that he has not spoken to Mr. Blaylock. However, I would like to advise the court that although Mr. Steele perhaps alleges that he has not received any information about this, the federal—
Hey, I need Mr. Steele in the courtroom. I don't know what the hell. Hey, man. I need Mr. Steele in the courtroom. This ain't no good representation right here. These cereal box lawyers got to go.
Represents someone on a related proceeding, and that is out of United States versus Cordoba.
Lily, if Mr. Steele wise here, you know what it stand for. Y'all staying longer. Ain't nobody getting out. They gonna keep dog too.
D as in dog. O.
See, dog. See, I told you.
That's a 2013 district court case out of the Southern District of Florida, but it is citing to United States versus Henry, which is 307 Fed APPX 331, and that's out of the 11th Circuit, and that's 2009. And specifically, the rule is that there is an irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. Further, that court found once it is shown that the prior—
Man, these dudes to hire the rat.
related to the current representation that it is
They lawyer a rat. What the
that relevant confidential information was disclosed. And further, an attorney's representations that he cannot—
Hold up, get them lights up. It's 170 people here. I need 170,000 lights. Birdman numbers on them lights.
Does not alleviate the potential conflict because the situation might change. So I think that's particularly pertinent in regards to Mr. Steele's representation of—
No cap. Then you just hear us say D and dog. They ain't going nowhere.
Point the court to Georgia case law, specifically the Height case that the court mentions, the 2013 case out of Georgia. And particularly the showing required, and this is also reflected in 11th Circuit precedent for pretrial matters, there is no requirement of an actual conflict, but instead, and this is from Height at 346.
This lady reading off so many different cases and so many situations with stipulations. Is he getting a bond or not? what is all this?
Not only by a demonstration of actual conflict of interest, but by a showing of a serious potential conflict. So the key language in this case, and in a lot of the cases out of the 11th Circuit and out of Georgia, is the existence of the serious potential.
The 11th Circuit sucks.
So
the potential conflict here is similar to that which is articulated in Height, which is if we would like to come to Mr. Blaylock, and we anticipate, and I'm putting this on the record now, if defendants in this indictment wish to cooperate with the prosecution and provide testimony against other defendants in that indictment.
Okay, so Blaylock a snitch too. They say he cooperating too. How he ain't even get talked to and he cooperating already?
Would be unable.
Remember she just said, well, ain't nobody talked to Blaylock. He ready to tell too. What type of Oh no. Oh no. We got two snitches. The lawyer still a snitch. The murderer Blaylock a snitch. Blaylock ain't even open his mouth. He ready to cooperate right now.
Because the prospects of the conflicted attorney advising the co-defendant about any deal that might be proposed by the state to secure her testimony against Height or cross-examining her on behalf of Height were rife with serious ethical problems.
Oh, the co-defendant got a deal already. What the hell going on?
The conflicted attorney's representation of both the co-defendant who had
Hey, notice how she said Blaylock ready to tell and stop talking about him just like that.
affect his representation of the main defendant.
Oh, dog ain't going nowhere. She talked about dog earlier.
To Lewis versus State as well.
Big Murph, I see you. Yeah, dog in the jam, bro.
But Lewis, which actually found that disqualification was improper, because there was not a.
Man, everybody sitting down just as confused as I am. What the hell is this lady talking about?
Actually possess information about the witness, but Lewis even recognized the serious potential of conflict rule. In Lewis, the court recognized that there was a risk, but in Lewis, there was not a significant risk. Here, however, there is a significant risk, and federal court has similar laws like this. So in another case that's out of the Southern District of Florida, which again is 11th Circuit, and I just point to it because it's pretty analogous to our case. It's called
This 11th Circuit, they don't do no work.
Gutierrez, and that's 2010 out of the Southern District of Florida.
Do you have another?
2009, 2010, 2011, 2013, 14, 15. What the hell going on?
United States District Court, Lexus 99424, but it does cite to law that will hopefully be that is out of the 5th Circuit, which of course became the 11th Circuit.
Now we to the 5th Circuit. What the heck? You know what? This is terrible.
An attorney cannot advise. So in Gutierrez, there was.
Spell Gutierrez for us again for
Yes, Your Honor.
myself and for Ms. Weaver.
Yes, Your Honor. G-U-T as in tie, I-E-R-R-E-Z.
Thank you, ma'am.
Now, in Gutierrez, there was an attorney, and he previously represented the cousin of a defendant. But the cousin of the defendant and the defendant were targeted in the same federal investigation. Although the attorney never officially represented the cousin did hold that attorney out to be his attorney. For instance, he gave business cards.
So the attorney represented two rats.
Investigators, but essentially that's actually less representation than what we have here with Mr. Steele and Mr. Blaylock. Mr. Williams and Mr. Blaylock by Mr. Steele. And specifically, the court in Gutierrez found that there was a conflict here. And first of all, the court noted that citing to Wheat, for a court to find a potential conflict of interest, both clients do not need to be charged in the same indictment or subject to trial in the same proceeding.
Oh, they tell it. This shit. All they these niggas tell it, boy.
So, further, the court in Gutierrez again mentioned that irrebuttable presumption of disclosure of confidential information wherever there is an attorney-client relationship, and that once it is shown that the prior representation was substantially related to the current representation, then it is irrebuttably presumed that relevant confidential information was disclosed.
This bigger than Dino Brown. It is, ain't it?
Serious potential for conflict here, finding that this attorney should be conflicted because, and this is quoting the court at page 14 of that opinion, moreover, Mr. Mitchell, the conflicted attorney, cannot adequately advise either of the defendant or his cousin about their option to cooperate against the other. And that's citing to Beatty, B-A-T-Y, versus Balcom, B-A-L-K-C-O-M, 661 F3D 391. That's a 5th Circuit case.
Man, is that Thugger up there? Why they got his mic off? Unmute Thugger. I need to hear what he talking about. Fuck that.
Quote from the Beatty versus Balcom case is the conflict of interest before trial alone would be sufficient to grant that motion, because had the attorney not been facing a conflict of interest,
Man, this about to go on for about 5 years.
To negotiate a plea agreement on one defendant's behalf in return for becoming a prosecution witness against the other.
Thug in that stretcher.
And I also want to point to another quote out of that case.
I don't know if you zip that. Should have told Yak Gotti to shut up. That nigga told.
Refuse to accept the waiver, such as what we have here between, there is of course a written.
That's why I say I don't know what shorty talking about. Unmute Thugger.
The court may refuse to accept the waiver where necessary to ensure the adequacy of the defendant's representation, to protect the integrity of the court, and to preserve the trial.
These niggas done told so much the same lawyer can't even represent them. They done told so much the same people can't even be in the same indictment. These niggas some rats.
Almeida, A-L-M-E-I-D-A, 341 F3D 1318, and that's 11th Circuit Court of Appeals, 2003.
They won't even unmute Thugger. He in that stretcher.
Here, we would
Zip
argue that
that.
it's very similar. In this case, we believe that especially Mr. Steele's, and to some extent his representation of his former clients, however, we believe a waiver on the record may be able to cure those conflicts. However, we would of course have concerns that even with those former clients,
Kimberly, oh yeah, they telling.
should they choose to testify against Mr. Williams or anyone else, Mr. Steele might be conflicted in his ability to cross-examine those former clients. But particularly, yes.
In terms of, like, several of these clients, Arnold, Greer, and Blaylock all have predicate offenses. Like Arnold is Act 11, Count 1. Greer,
The jury like, hold on, all these niggas ain't getting out. All these niggas got cases. Who telling the most? That's who we go let go. Who ready to tell everything?
be a potential issue if I'm looking at potentially a resolution or some other issue related to this case. Wouldn't that pose a potential or an actual conflict?
Yes, Your Honor, it absolutely does, and that's
210 people in here. Make sure y'all get them likes up. Make sure y'all hit that sub button.
Because our biggest concern is that he is currently representing Mr. Blaylock. He is Mr. Blaylock's attorney of record. Mr. Blaylock, although he signed a waiver through another attorney, Mr. Blaylock is actually unrepresented in this case. And the only representation that Mr. Blaylock even has right now is Mr. Steele on his appeal. And as the court, I'm sure, is aware,
Blaylock got Mr. Steele and he can't use him. Whoa, there's some buffoonery right here.
To say, hey, we'd like to cooperate, but he can't even do that because of this conflict. And so that's why we started with Mr. Blaylock. I would also
Mr. Blaylock in the jail, he better zip that. There ain't no point of him telling. He ain't got no representation. You ain't got no representation for the conversation.
In case number 10 SC 92020, and we certainly appreciate Mr. Steele bringing this to the court.
Local, we're liking sub again.
As I noted in the original motion, we were trying to file that as soon as we could to make sure that, you know,
no cap. Why do 10 when you could tell on a friend? Man, Blaylock about to. Shit, he ain't got no representation.
But as soon as we learned about that representation,
that's why they started with him first.
And we noted that Mr. Greer is actually, he was convicted of murder. That case was reversed. The state will be trying that case again. That case is presently before this court.
He had a murder case that got reversed that he still got to go back and fight another murder case?
Is still Mr. Greer's counsel of record.
Who the hell is Mr. Greer?
Mr. Greer wished to cooperate, perhaps negotiate some sort of resolution to both of his cases.
Hey, Mr. Greer, nah, you ain't do it. Guess what? You did do it. What?
Obviously, the serious potential for conflict that I've described. So that's another one.
South Carolina in the building. What up?
As the court just raised to me moments ago, we do think that there are serious problems with the former clients based on especially the federal case law that I've discussed, where there is this irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. And when that issue is substantially related to the current representation, which obviously it is, these counts are the predicate acts for the present case. We think that there is an irrebuttable presumption that relevant confidential information.
Yeah, I'm tired of her talking for Mr. Steele. Where's Mr. Steele? We need him in the building for sure.
I'd like to point the court's attention to another case out of Georgia. The Georgia court.
We got another case. God damn.
336.
We gonna be here till tomorrow. Y'all what? I should just call off work right now. Y'all think we finna be here all day?
784 SE 2D 924. That's a 2016 case. And in that case, the defendant's attorney had formerly represented the victim's mother in a previous proceeding. It was a child molestation case that was on trial. The court found that there was a serious potential for conflict there. And although a
child, what? Oh no.
The court,
oh no.
The trial court found that the Court of Appeals found that the trial court properly declined to accept that waiver because the defendant's waiver of his attorney's conflict of interest does not always cure the problem, because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. And that waiver does not work, and this goes to one of the non-waivable conflicts in 1.7C.
So the waiver's not waivable? What the? What? Hey, these niggas cook. I ain't heard not one good thing come out this lady mouth.
Motions today, and why we are so concerned is because as the
Shit, I'm concerned too. Shit, you ain't the only one. I'm concerned too.
Conflict-free representation, and so that's
we here for dogs. Yeah, free dog.
Where conflicts cannot be waived, allowing the trial court to proceed to verdict would have created a serious potential for error sufficient to allow Edwards to obtain reversal of any guilty verdict by claiming on appeal that he was prejudiced by the conflict. So,
yeah, I ain't the only one telling.
To sum up my argument, basically, first of all, while we appreciate the written waivers, we believe that if the court is even willing to consider waivers to cure any of these conflicts, those waivers would need to be here in person on the record, where the defendant could confirm to this court, and this court could observe that defendant, everything around him, his demeanor.
Basically, what she's saying is, if they snitching, it got to be documented that they snitching, so they can get their waived. Goddammit.
He has received in writing reasonable and adequate information about the material risk and available alternatives, and he's had the opportunity to consult with independent counsel, and those rules are out of Taylor, which I cited earlier. But again, our position today is that some of these conflicts, particularly the conflict with Mr. Blaylock, and to a lesser extent, the other former client conflicts, including Mr. Stillwell, Mr. Kendrick.
She ain't even got nothing else to read off the paper. She just talking. Where's Mr. Steele at?
Attention to our concern with Mr. Stillwell is that we believe.
Oh, she backflipping, Lord.
Is also facing a conflict, and his counsel is who got the waiver on this case.
Neil, I'm lost too. But I know what she's saying. That if they want them waivers, they got to tell. It got to be in the waiver to make it waivable.
For conflict, because basically
no telling, no waiving, goddamn.
Those plea offers, the attorney would not be able to negotiate that in return for becoming a prosecution witness against.
Some of them can't even use the lawyers they got.
For instance, Mr.
This the craziest case I ever seen in my life.
Is in a leadership position in this gang, which is why these are particularly concerning allegations. And one moment. That's all I have for the court at this time on why we believe that this court should, first of all, request any waivers be on the record.
Man, I'm mute, Thugger.
We would ask that this court grant our motion to disqualify Mr. Steele on the grounds of the 1.7 and 1.9 conflicts. Thank you.
Oh, Mr. Steele can't be their lawyer no more?
I'll let you respond.
Damn. Oh, there he is there. Come on up, Mr. Steele. They don't even want him on the case. And then this nigga a rat. Want him on the case.
Sharp, and then I'll let him respond, okay?
Is this Steele right here?
All right, Mr. Bullard, good morning, sir.
Oh, no, this is Mr. Bullard.
Oh, no, we have been here a while, Your Honor.
Yes.
So first, Your Honor, I'd like to thank Mr. Geary and Ms. Rosenwasser for their professionalism and candor in foregoing the Rule 3.7 issue. We always felt that that wasn't going to bear out, that there was no way Mr. Steele could be a necessary witness in this case. Gladly, on investigation.
Here go another nigga that ain't Mr. Steele.
As for the Rules 1.7 and 1.9 issues, however, I know that Ms. Rosenwasser didn't quite give the court the full picture.
Yeah, Smoke, we know they all telling.
As Your Honor noted, to require disqualification, the state has to allege and substantiate a claim of an actual conflict of interest. Now, we are in a criminal case, and we're talking about the Sixth Amendment context, where the one's right to chosen counsel.
Oh, my man stopped at Walgreens to go grab the tablet. It's over with.
It is not absolutely wrong.
So I think that the case law kind of walks us through that. So let's just kind of go through that.
Sure.
I understand he has a Sixth Amendment right to choice of counsel,
Yeah.
but in this particular circumstance, the court has to be, you all have solved.
The judge letting them know these niggas cook. Ain't no getting out of this. These people is terrible.
Been an ethical violation and the issue of whether there is, some type of substantiation. So let's address that.
All right. So first, I'll turn this around then. As for the waivers, Your Honor,
Do you believe that I should go ahead and hear those, have those in, given what Ms. Rosenwasser has cited, I believe in, it's Taylor, that was.
This man stuck. He don't know what to do. He don't even know which way to go. Your Honor, but Your Honor, but what she said was, notice the judge ain't even let them say too much, but he let the girl just ramble.
the individual defendants in, having the court inquire whether they fully understood the rights they were advised of, and whether they have actually waived.
Yeah, Gotti told on dog too, man.
However, that the rules of professional conduct describe written waivers as appropriate on consultation with independent counsel. And that's what we have here, Your Honor. We have several lawyers.
But he definitely looked like a public defender. Not a PD. Oh, hell no.
Ethical.
He got a Walgreens tablet. All his notes disappearing off the paper.
Or in any way, he has the highest conduct.
Judge ain't even letting them get his point across.
Having watched him for the better part of 25 years. So that's not the issue. The issue is the system and its ability to be fair and transparent. So part of the challenge is unlike the civil case.
Judge, the issue, unless all these niggas tell, they gonna stay their ass in jail.
Criminal cases are unique in the sense that you have multiple accused, you have divergent interests. And as the longer the case goes, or at any point in time in the proceeding,
Oh, we gonna be here for a while, y'all.
opportunity, meaning that, and I mean opportunity in this case, I'm not on either side, but where a deal.
I don't need to side, but if niggas start telling nigga get it over sooner, if not, nigga, it's gonna be a while.
I'm sure that all the parties who are in the best position, should they choose to do so, to participate in that. And I think that
240 people. I need 240,000 likes. Birdman numbers on them likes.
troubled by is that divergent interest and likelihood. And in criminal cases, especially where you got 28 folks, you're going to have that particular issue. And
Mark P, according to what the judge said, unless they all ready to tell right now, it's gonna be a while.
specifically referenced in predicate offenses, as part of the RICO count. So
See, I thought this was gonna be just Young Thug Bun. They ain't said a word about him yet. They talking about Blaylock and Steele and everybody else.
the state's going to be fruitful in this, but that would be part of the reason or what they proffered. So I'm going to take judicial notice of the indictment. I'm going to have it admitted as court one because it does go ahead and
Yeah, that's where I'm translating for the judge, Neil.
the predicate offenses.
Yeah, Lily, he might get more than that though.
Some of the concern under 1.7, but
Man, I'm tired of 1.7. They need to get rid of that road. Straight up.
If I can address that.
Yeah.
Sure. In a multi-co-defendant case, there is always the possibility that there may be interest, because we don't know. That at some point, one defendant may want to turn on another.
This lawyer know they cook. He ain't even iron his suit.
Able to negotiate their way out. For one reason,
This nigga representing Bubba ain't iron his suit. Oh
At
no.
this point, Your Honor, that is speculative because we don't know that's going to happen.
Ms.
Ms.
Rosenwasser
We don't know what's gonna happen. We don't know who I'm telling yet, y'all.
a likely that's more than a likely probability that once the representation issue is resolved, that they're going to go ahead and, as part of their prosecutors' tools, do that.
Sure.
So basically, what they letting y'all know is only one of them could hire the top lawyer.
majority
Everybody else gonna have to get different lawyers.
Conditional. We don't know whether those defendants would be interested. We don't know what the offers would be, and we don't know whom the offers are coming to.
Oh, he getting mad now. We don't know what they offer. We don't know what to do. I don't know what to do.
Who is still,
This motion for new trial is still pending.
I know, but
This nigga ain't did one trial, got a motion for another one. What type of telling y'all doing?
can you have two conversations with client Williams and then client Blaylock on their relative equities and what they should do? If,
Lily, you heard that? Oh my God.
If that were to come up, Your Honor,
That man up there mad as hell. Wait a minute. We don't know who gonna tell. Wait.
In that matter, with respect to this one, it might well be a problem. And again,
Oh, it's a problem, y'all. This gonna be like another 2-3 years right here and there. If we can't get through a simple is they getting bond or not, we got a long way to go.
Murder against Mr. Blaylock, and so I'm not sure how much more of his life it intends to take. Nevertheless, Your Honor, but when we are this, Ms. Rosenwald.
Oh, he frustrated.
Concern about the state's concern.
Nevertheless, you frustrated. And your suit next time.
Judgment against Mr. Williams in this case would be insulated against reversal on these grounds. Well, let's talk for a second about what would actually have to be shown were that to happen. Assume, for the sake of argument, that Mr. Williams were convicted. The law from the Supreme Court of the United States is that he would have to show an actual conflict, which is not just a violation of ethical rules. It is not a theoretical division of loyalties. The Supreme Court says in Mickens versus Taylor, it is that Mr. Steele's representation would actually have been affected.
Still, done already told on these dudes he can't even represent, man. That's crazy.
And all indications are that Mr. Williams is going to trial. He would have to show that Mr. Steele's representation was compromised. And Your Honor noted that there is no question about the quality of Mr. Steele's advocacy and whether it would be compromised and what kind of advocate he is. So it's hard to imagine that it would be compromised here. Now, if the state were to make an offer against Mr. Blaylock, one, there's a waiver already. And two,
I thought Rollo was gone longer than 4 years. Yeah.
getting out of that case,
He been coming home, man, yeah, since he been gone.
then that counsel can consult with Mr. Blaylock, and then Mr. Steele could consult with Mr. Williams.
how do you address the issues of the 11th Circuit and
Hey, Chris, you a mod. You ain't got to argue with nobody, bro. Just zap him.
of disclosure of confidential information?
Your Honor, that one, I know that presumption has never been adopted by a Georgia court. That is a presumption that's been adopted by the 11th Circuit. The Georgia courts haven't adopted it. And two, even if we were to presume the transmission of confidential information, that alone does not create the actual conflict of interest or the serious possibility of one. I turn the court to, let's say Lewis versus the state. Actually, no, I take that back. Williams versus the state, which is cited in our motions, a case that arose out of Savannah.
This nigga bringing up other cases. What that got to do with what we talking about? They could. Bro, we can't get through a simple is they getting bond or not.
And then
He bringing up other cases.
represented the court that he did
Trying to make a point. Nigga, the judge done already told you, look, it ain't going down like that.
trial because of the then
Gucci stopped saying free Rollo because he thought he was out already.
one.
That's why Rollo been coming home, man, yeah.
The court in
Capricorn, I see you.
determined that he didn't know enough about the other case, that his representation in this case wouldn't be compromised, and allowed him to go forward. Mr. Williams raised that issue on appeal, and the Supreme Court affirmed.
See, you know what happened?
Because
See,
he did not
they done jumbled this indictment up so much. They got so many different things in there. Now, all this different stuff got to be talked about, discussed, chopped up, and come on, man. It don't take all this. Is these niggas getting a bond or not? Buddha got stuff to do.
Dive into that case
Damn.
because what you have there was the former superintendent of the DeKalb County Schools, Mr. Lewis, who retained a lawyer, Mr. Brown, who was a member of the firm Alston and Bird. Alston and Bird also represented a witness in a number, or a witness's employer in a number of matters. And so the court inquired. There were representations made on
This dude is talking about a whole nother case that ain't finna make no point. They already trying to tell him what it is. He trying to tell him what happened in the other case.
And the employer were the same, and whether there might be some conflict of interest between.
Now the judge finna repeat to him everything he already told him, because pretty much that's all he got to do.
Yeah, the rigor of cross-examination, which is also something the 11th Circuit talks about repeatedly, whether there is going to be.
The 11th Circuit suck. You get locked up in the 11th Circuit, I'll pray for you.
Or whether there might be an interest in not cross-examining as vigorously as possible. And in that case, the Superior Court of DeKalb County disqualified Mr. Brown defense counsel, and the Court of Appeals reversed.
But isn't that different than what we have here? I mean, that seems.
The judge, hold on, nigga, that ain't the same case, nigga. This ain't the same situation, nigga. These niggas go talk. If not, they ain't go walk. It's just that simple.
Then Judge Blackwell.
Nigga, you ain't even iron your suit. Ain't nobody taking you serious. You ain't iron your suit. Man, get dude off the panel, man. Straight up. Unmute Thug. Tell him what it is. Let him talk.
Even if counsel stated
We got the leader up in the corner. He up there stretching. The camera could go back to Thug. I don't even want to listen to this dude right here. If he ain't representation, they cooked.
Extraordinary remedy of disqualification of counsel of choice. And all that the court
He using all these big words, though none of them matter.
On conjecture, because we're speculating out there. So the claim there wasn't substantiated, just as the claim here hasn't been substantiated. We're speculating. I would also, since we're talking.
Hey, Mr. 3,000 feet. You take your ass 3,000 feet up off my channel, bro. This man ain't saying nothing. What you mean let him talk? He ain't saying nothing. He talking about other cases and the judge telling him they don't matter. What are you talking about? I just told you what he was saying. Nothing. Look at him. He ain't iron his suit. Ain't cut his hair. Ain't iron his suit. And trying to talk about other cases to make a point in the case. They ain't got nothing to do with each other. What you mean? He running around passing out papers. Them ain't nothing on them papers. Yeah, the judge fed out with Buddy because he ain't saying nothing.
We're law partners and multiple co-defendants in an indictment.
They cook. They cook, bro. It's terrible. They cook.
Civil matter, and the co-defendant had, and then the father took on the representation of another co-defendant in the criminal matter. The co-defendant, the information from the civil matter was germane to the criminal matter, and the representations made by the co-defendant would have turned the son into a witness. Now, the Middle District of Georgia, applying Georgia rules of professional conduct and inquiring into the case.
Capricorn, he got an attitude because he ain't saying nothing. The judge know he ain't saying nothing.
Representing the co-defendant in the criminal case.
We trying to see if they go get Thug a bump, but I doubt it because he up there stretching. It look like he tired.
Similarly, we have, or relatedly, there was also not an issue with, there was not a showing that the confidential information might have been material to the case. So even if there's a presumption of confidential information, it does not.
Confidential information. That had to come from a confidential informant. All right, you talking now? Hold on, say something else important.
And in that case, what the court did was say, look, the lawyers are presumably responsible for figuring out whether they have a conflict or not. The government has not.
Hey, Cinnamon, you get your spice rack head ass off my channel. This man ain't saying nothing. I ain't got to be quiet on my stream. You go watch the shit somewhere else. The man ain't saying nothing. I'm going to be quiet when he say something important. He ain't talking about nothing. He talking about other cases. We ain't here for that. We here for the dog and we here for Young Thug. If it ain't about the slam puppet Thug and if they getting bond, we ain't here for all that other stuff.
To be guessing about what's going to happen. The state maybe may be.
And I'm still mad he ain't iron his suit.
Say, we don't want anything. And they may say it to counsel other than Mr. Steele.
That would be, of course, they're truthful advocates. I mean, I'm not saying that what's in the indictment, they have to prove all the material allegations in the indictment as part of their case in chief. But certainly, if these were not in there, I would tend to believe that it's more than just mere speculation. They can prove it. So why would it be not? Why would it be speculative?
Because, Your Honor, just because those charges are there does not mean that it would be speculative that the several defendants would be interested in pleading. It would be speculative that the several defendants, that even if they pleaded, that their interests might or might not, their potential testimony might or might not be potentially adverse to Mr. Williams. It is speculative what the offer would even be at this point. We just simply don't know, and there's not enough evidence to substantiate that.
Yeah, you don't know nothing. You go sit your ass back down. You don't know nothing. he don't know nothing.
With Berger versus Kemp, which is a case from the Supreme Court of the United States that actually grew out of Georgia, I think down in Ware County. There we have law partners concurrently representing co-defendants in a
We got law partners. Well, you should have brought them because you ain't said shit.
Might well have the interest in turning on the other. And they challenged their conviction all the way up to the Supreme Court of the United States, and the Supreme Court said that that was not enough to show an actual conflict of interest in that case. So it just simply does not, it simply takes more to demonstrate an actual conflict than, well, this might happen. The joint representation, the simultaneous representation is enough, because in Berger versus Kemp, the Supreme Court.
This nigga bring up one more other case, boy.
Imputation that law partners, that is the same as one lawyer representing, but simultaneous representation by a single lawyer in a case where they might have adverse interests.
I know PT, the judge already told him them other cases ain't the same situation.
Is not by itself a basis for disqualification. In fact, I think in
my cousin Vinny
all three of those cases cite back to an opinion by Justice Frankfurter and Grasser. It was an opinion.
Kendall, you wow.
The majority adopted that point that that a common defense might often be better strategy.
Judge on Amazon or
And the existence of natural conflict does not turn.
Judge on Amazon ordering air fryers and shit.
And we are speculating. The
Damn.
other thing to remember here, Your Honor, is that an erroneous deprivation of counsel at this point. I mean, the state is concerned about ensuring that any judgment in its favor is stable.
He ain't confused with the judge. The judge on Amazon ordering air fryers and he ain't trying to hear none dude saying.
What quality of counsel Mr. Williams received at trial? If he's convicted, there's no showing of prejudice for reversal. He was denied his chosen counsel. His chosen counsel, with whom he has a
Lily, exactly.
Of almost a decade. His chosen counsel, who's intimately familiar with his business.
And the judge trying to tell him that ain't finna happen.
Who has advised him in a number of matters, and who is simply not replaceable, even by other competent defense counsel, because he has been chosen. And even if the court were to find a conflict, it still has to balance the risk of the need for ethical conduct and the
Precious, how they gonna find him?
and the
Apparently they whole team.
against those concerns for the defendant. Even if we got there,
He ain't only the client, he the president. Apparently,
the state had
we don't know what Mr. Steele at.
which we still say it doesn't. Let me sort of loop back to two other.
Neil, Buddy ain't said nothing.
As far as substantiation goes, Ms. Rosenwasser mentioned Edwards versus the state.
The judge back there playing bingo.
And the appointed public defender
Judge ass playing bingo.
a defendant in represented then a defendant in a child molestation matter, and the state's principal witness was the mother of the child, whom
I ain't see nothing about this child stuff in the indictment. What's going on with that?
under previous practice represented, I believe, in a divorce matter, not a divorce from this defendant, but a divorce matter, and there, the public defender himself put on the record that he was aware of confidential information that would affect his cross-examination. And that affirmative representation...
He talking about the public defender done gave up the confidential informants. What's going on right here?
So the defendant wanted to go on with his chosen counsel. The other thing, though, is completely different from what we have here. In Edwards, the witness, the former client, had offered no
PT, I don't know. He keep going back to that case, though.
Did not accept that upon investigation, the public defender's representation that he could navigate around the confidential information. So he was trying to be ethical, but he conceded on the record that his representation would be affected. So there is a basis to infer that.
That's a little different because, I mean, still on the rules, all of us have.
Mr. 3,000 feet, you not blocked, bro. What you talking about?
Conflict develops too, and potential that at the time the conflict is present to raise that to the trier of facts. So
Yeah.
he was doing what he was supposed to do.
Oh, absolutely, Your Honor. But the point is, when the issue went up on appeal, the court was not wrong in granting the mistrial because it concluded that he could not be effective. But
I'ma come to St. Louis when Chingy drop another album.
Would justify that conclusion as opposed to, say, Louis, where we were speculating, or even in.
But doesn't that
Man, we over an hour in. These people ain't said nothing.
Anybody who's been practicing criminal law for a while will tell you
To the bone, I see you.
conflicts often develop kind of at an instant.
This judge mad as hell. I'm stopping my bingo for this nigga.
Or evidence is
You interrupting me ordering off Amazon for this nigga.
But that's when there are people that think there's not a conflict then develops, and then
You think it ain't a conflict? It is a conflict, nigga. It is a conflict, nigga.
salvage or even sometimes.
What up, Alexis?
Proceeds because somebody is pulled out because the conflict has developed through representation. So isn't that something that may potentially happen in this particular case, given the fact that you got 28
Judge got a coffee cup, no coffee.
and, I mean,
Man, zip that.
speculation, state hasn't offered anything else yet. Isn't that
Damn.
part of the issue that the court as the arbiter and keeper of the process should be worried about?
I'm not saying the court should not be concerned, Your Honor. It is potential. Potential, however, does not mean serious potential, which is what.
Shouldn't we be worried, nigga?
Serious potential that we've got 3 people that are that have predicates that are in the indictment.
No, Your Honor, I don't. Not at this point. Not without more.
We got 3 people in the indictment that's already cooked. We ain't got no reason to be worried, nigga.
Attempt to make an offer.
They ain't getting no offer, nigga.
All right. You're making an offer, and
Hey, man, this shit terrible. This shit terrible. This is
If
terrible.
the court were to actually make the offer, maybe we'd be in a different posture. We need to do something to address the conflict and perhaps change the posture of one of the defendants from present to former, and that's something that Mr. Steele would have to deal with. But that, or especially with Mr. Blaylock. But
doesn't that pose a problem for the people who are that Mr. Steele is
The judge about to walk down there and smack this dude. He's steady trying to, but no.
The worry that the current client is going to potentially roll on them, or got involved being given adverse testimony to against their interests.
Well, let's take that for a second, Your Honor. So let's say an offer is made to Mr. Greer or Mr. Arnold or Mr. Stillwell Jackson. I know his name is Stillwell in the indictment. I think the waiver indicates the name.
Mr. Steele, Mr. Stillwell, hold on. What the hell? Wait, what?
Made through other counsel, and other counsel are going to consult with him or with them, and other counsel are going to advise them of the risks and benefits, and they aren't going to be able to get. And they aren't going to have a claim because they have other independent counsel advising them that the representation they got in this case was adverse. The only person who even might, and we're not there yet, the only person who even might is Mr. Blaylock, whom Mr. Steele represents in a different, though factually connected matter. We don't know if there's going to be an offer there. We don't know if this is all portion
At this point, Lucci rubbing his hands together like Birdman.
Of the judgment it has, and it is now trying to defend against an appeal. but it just simply hasn't happened yet. And we also, let's assume that assume for the sake of argument that Mr. Steele withdrew from that representation. Mr. Blaylock had other counsel. The counsel he had then could advise him.
He hasn't done that yet.
He hasn't done that yet. But again, the state is speculating, well, this might happen. We might make this offer. Mr. Steele might withdraw. He might have other counsel. He might be properly advised. If we're talking about protecting the right, the interests.
How can he represent the interests of Mr. Blaylock, who's charged in Acts 76 and 77?
This man don't listen.
74, 76.
Damn.
And the interests of Mr. Williams at the same time.
He ain't defending both of them no matter what y'all try, nigga.
So concede that in the motion, as Rosenwasser indicated today.
Interrupting my bingo for this. The judge blew.
If we become adverse, then Mr. Steele would be the first person to come to the court and say, oh, now we have a problem. I need to either withdraw from one representative.
Well, where the hell is Mr. Steele at? If he not, can we please get him up there?
Back to the United States versus Harrison. At the end of the district court.
Damn, this would have been over with an hour ago if Mr. Steele was up there.
For conflicts to arise, and it reminded counsel of their obligation to inform.
Mr. Steele had to know they was cooked. He took off.
Should the conflict or the serious potential for one.
Visual, he's saying woulda, coulda, shoulda, woulda, woulda. Yeah, that's exactly what he's saying.
Your Honor, steps would have to be taken, but that one does not mean steps could not be taken to preserve make sure that everyone had the right to effective assistance or conflict-free counsel. And in addition, that any judgment obtained against them would be sound, because when they had received the advice and made the decision to plead or not, they would have had the benefit of independent counsel who didn't have these problems. It simply doesn't mean that. But all of these things could happen, and it would still protect.
Man, I don't know what this talk about. I ain't gonna lie to y'all. I don't know what the fuck he talking about.
Okay. Anything else?
Judge, like, man, you made me miss a move and check us, nigga.
I would come back to, Your Honor, that even if the court were to find the state has substantiated a conflict, there is a serious potential for an actual impairment of Mr. Steele's representation that could not be cured through withdrawal or something else. That when it comes down to balancing the equities, we have to talk about what Mr. Williams loses in this case. He loses an excellent lawyer, one whom he believes to be the best of the best, and rightly.
Oh, so Young Thug gonna have to get another lawyer.
And
better zip that. He gotta get another lawyer. Oh man, this case gonna go for about 2-3 more years.
And there's also going to be a significant financial cost and loss of effort that's already been put in, and all of that counts, Your Honor.
Thug gave them $2 million, and he finna lose the lawyer. Oh no.
Then it still has to balance the equities before making a decision. And the burden is still on the state to show that the extraordinary remedy of disqualification is appropriate.
Wow.
And lastly, Your Honor.
So basically,
moving back to the beginning,
the still got to decide if he gonna defend Blaylock or if he gonna defend Thug, but he can't defend both of them.
Because more than anything else,
That's crazy.
Insulate a potential judgment against.
Damn.
On these grounds.
Better zip that.
Once the waiver has been placed on the record,
First get the money and the power.
Claim they received the ineffective assistance of counsel because they would have induced the error, and induced error is an absolute bar to reversal.
But hold on, but if they drop your lawyer, do you still got to pay? That's $2 million down the drain. Damn.
Go ahead. How are you doing in person?
Well, I don't think Blaylock got $2 million, so Blaylock go his Blaylock got a rat because he finna.
I wanted.
Well, he finna lose. He finna lose still, so he got a rat.
I want that on the record, regardless of what I ruled. Okay. All right.
So I guess that brings us to the question: if the court's not ruling today, Mr. Steele had planned to argue the bond motion. I know there's no.
Oh no! Here you go. See what I'm saying?
I have to resolve.
How can you see? This is the problem.
As I mentioned.
Still can't do nothing because he can't represent multiple of them that's tied up in this case. So you mean to tell me we had a bond hearing when everybody knew it wasn't gonna be no damn bond? Oh no! You better zip that. I'm mute Thugger right now. I need to hear what Thugger got to say.
But let
Judge already kicked one person out of virtual court.
Okay.
We done with you. Who? Talk to me. Who?
I thought you were represented by counsel now. You can't have a twofer, sir. It's one or the other, all right?
I'd like to answer some of your questions if it's okay with the court.
Damn.
All right.
Who is this? Ain't no twofers. It's either one or the other, bruh. Hey, this Judge Cole. This Judge Cole, man.
Your Honor,
What you
I
want?
heard you ask multiple times predicate acts in the indictment.
JP, I don't gotta listen to the court when they ain't saying nothing, bro.
I need you to understand the following, please. Mr. Arnold, I never represented Mr. Arnold. You will find nothing that I have ever defended that man. I have never spoken with him about his case that there are predicate acts in this indictment.
I want to ask something. Does the state want Mr. Steele to testify about this? Because one of the things about these types of motions is there has to be some evidence. So if you're gonna, I mean, I know you're an officer of the court. You would not tell me anything inconsistent with that, but that is something that would have to. Part of my determination has to be based on evidence that has been granted, has been given in this case.
Your Honor, the state's position is
Oh yeah, Lily, his suit, he ready.
Back up to ask to just have the court take judicial notice of the exhibits I had already admitted. However, if Mr. Steele would like to testify, I would just simply like the opportunity to ask him.
Mr. Steele gotta testify.
I don't object to him testifying on his own behalf right now, and I can ask him some questions afterwards.
Mr. Steele, I've had one of these go up before, and that's part of what was the other lawyer that raised the issue. Did ask those particular inquiry under oath. Do you have an issue with that, sir?
No, sir.
Okay, all right. Go ahead and swear me. Raise your right hand. Do you solemnly swear affirm the evidence you'll give me in the case down here should be the truth, the whole truth?
Damn, Steele gotta talk right now. Hold on, y'all. Hold on.
All right, go right ahead.
With regards to Mr. Arnold, there was a shooting at Lenox Square Mall. I was at my office. I received a phone call, not from Mr. Arnold, and I don't know who it's from, but it's one of his supporters. It was either a manager or a female friend, is my memory, and said, the police are all over the mall. We're afraid that they're looking for Mr. Arnold. Would you please find out if there's a warrant for him so he could turn himself in? I was busy I was either on trial or doing an appeal. It's a long time ago. There's no file in my office. I asked another lawyer in my office, not affiliated with me, named Travis Galan, G-L-A-N, to go to Lenox Square Mall and find out if you could find out who is the police officer involved. Is there anything from Mr. Arnold? Travis Galan went to Lenox Square Mall. He got the name of an officer. I contacted the officer. I told the officer that I was contacted. If Mr. Arnold needs to turn himself in, if there's a warrant, then he would do so rather than the police have to potentially, I'm not saying anything this would happen, but go and waste resources finding the man. The officer told me, meet me at the police precinct. It's not far from the Honorable Don Samuel's office. I was there. I remember very late, 10 o'clock, 11 o'clock at night, the officer finally either showed me a warrant or gave me his word there's a warrant. I called a supporter. I said, there's a warrant.
Who shot up Lennox?
In the records, when the state raised this, they attached one page of an unsworn statement of a witness that says that I supposedly, and it's worded where you don't really understand it, but I supposedly made a statement, a confession on behalf of my client. I never spoke with Mr. Arnold in my life about that case.
Oh no, what happened? Oh no, no! They ain't never just cut the stream like that. Oh no, what happened? Oh, bruh, they cooked, bruh. Bruh, they cooked. They is cooked. Lily, Alexis, y'all don't see that they done cut the stream. Oh, they cooked. They ain't want to show us what's really going on. Oh no. So you mean to tell me it was working fine until that man started talking. Oh no. Oh no. Something ain't right. They done cut the string? Oh man, them niggas cooked. Them niggas is cooked. Oh, bro, they done cut the string, bro. Bruh, they cut the string. What the heck? Hey, y'all. I ain't gonna lie. I didn't do this. The stream is been officially cut. Notice what they just did. They cut the stream when Mr. Steele started talking. The person that we was waiting on to start talking. All this mumbo jumbo came, and then they cut the stream. I don't know if this stream coming back. We gonna give it about 5 minutes.
For Atlanta's traffic expert,
We've seen delays.
Who is that? What's this?
helps you get there on time.
Hold on. Okay, we back, but what is this?
Morning news.
Get back to Mr. Steele. What the hell?
Watch weekdays 5 to 7 a.m.
Boo, they ain't do this, y'all. This ain't no camera effects, no tricks, none of that. I don't know what's going on. How did they cut the stream soon as Mr. Steele started talking? Who shut up Lennox?
Download the 11 Alive News app to use near me.
Oh no.
11 Alive News at 11 p.m.
So this how they after we've been waiting all this time, this how they play us.
Across Metro Atlanta.
This how they play us, right? So they don't want us to know what's really going on. That's what they trying to do, y'all. I hope y'all seeing this.
And the only place where
What's with all these commercials? Come on, man.
11 Alive can verify that claim is false.
An hour and 20 minutes in, we ain't had not one cut, no commercial.
you're ready to take on tomorrow.
They cut the whole string.
Weather can't run from the 11 Alive Thunder Truck. A mobile weather center with the power.
They still streaming, they ain't cut the case. So you know we ain't even seen nothing else with Mr. Steele talking to nothing, man. I'm gonna give him 10 minutes, man. Damn, we up out of here. I appreciate everybody for coming through.
Is on all of us.
But this the type of stuff they do.
Committed to sharing
By the time we get back to the courtroom, we gonna be back to seeing your thug doing stretches.
voices for equality.
The cameraman battery died. It better not have. Now when Mr. Steele got to talking,
Live storm track.
this crazy.
How you see weather happening now across.
Oh, bruh. Oh my God, I can't believe this.
What's coming overhead.
They don't want us to know what's going on, man.
Pop-up thunderstorms and rain.
I can't believe this.
How you be weather ready. You're
I
in
can't believe
We
this.
expect at any moment a tornado warning could be issued.
the 11 Alive.
They cut the string.
It's how you'll be prepared and stay safe. 11 Alive Morning News
We began with breaking news this
is
morning.
where you know what's happening now.
11 Alive is live on the scene.
Where you can confidently plan ahead,
This severe weather is intensifying.
Bruh,
knowing what's coming.
they didn't go to recess.
And where it
They
is.
didn't call lunch.
We've seen delays.
The judge was playing bingo, ordering stuff off Amazon. We finally get Mr. Steele up here, and they cut it.
Is where you
And they cut the whole string.
watch weekdays 5
Pray for YSL, y'all.
If you see breaking news or
They definitely staying longer. Y'all staying longer. We got to pray for them now. They don't even want us to see them on virtual court.
record your question.
How you cut a stream like that?
The 11 Alive News app.
Oh man, it's all bad, y'all.
11 Alive News at 11 p.m. is
Oh no, yeah, I'm finna get up out of here. They ain't rolling nothing but commercials, y'all. I got to go. It ain't even.
where you stay.
I'm gonna give them 5 more minutes, man. They got 5 more minutes. Oh man, I ain't finna mute this. I don't need to be hearing all this, man. They tripping. Soon as we get to the who shot up the mall and who doing this, who doing that, they cut the whole string. Oh my God, I can't believe this. I can't believe it. Man, they probably beating Thug up all in the camera room. Ain't no telling what's going on right now. They cut the stream on us. We don't know what's going on now. We was about to get all the answers we needed from Mr. Steele, and they cut the stream. I can't believe this. Y'all seen what just happened yesterday with Amber Heard and Who that? Amber Heard and Johnny Depp? Y'all seen that, right? That's what made me want to stream this. They cut it. They don't want us to know what's going on now. Yeah, remember the dude, Mr. Steele, we talked to y'all for an hour about? Send them some commercials. What? Quelly, they cut the stream from the court. I'm trying to find another one to pull it up from somewhere. I can't find it on no other channel. They cut the whole court stream. That's crazy. Bro, they cut the whole stream from the court. Them dudes cook. They don't want us to know nothing. That's terrible. I don't think they coming back, y'all. I ain't gonna lie. I appreciate the ones that came through. Shout out to y'all. Young Thug finna need to lose $2 million or Mr. Steele. Mr. Steele can't defend Young Thug and Blaylock and the other individuals on the case. He can't be everybody's lawyer. He can only be one person lawyer. And that's where we at with it, y'all. I appreciate everybody that came through, everybody that stopped by. I don't think they coming back. I'm going to try to figure out and find out what's going on, man. But y'all seen how they ended the stream on us, man. Sabutalai. This is crazy, man. I'm about to go ahead and get up out of here, man. These commercials driving me crazy, man. Y'all make sure y'all subscribe, hit that like button, hit that Cash app. And the next time, we coming back. But now we got to come back every single time. But y'all seen how they just cut the string. They don't want us to know what's going on. And you seen when Thug and them people started talking, it ain't going their way. So if it ain't going their way already, this might be a bad situation. It's your boy Buddha, man. I'm out.